Welcome, everybody. Um, my name is Dror Futter. I'm an attorney at the law firm of Rimon. Uh, my practice covers both financing and commercial transactions of startups and small businesses. I'm going to upload my presentation, which took me a second before. While we're waiting, I encourage people to message me questions during the course of this presentation. We have a lot of content to cover. The goal of this presentation, which is entitled Legally Speaking, 10 Tips for Running Your Business in a Crazy Corona World. The goal here is not to kind of give you a legal education, but it's to really put some issues in front of you that you should be thinking about. You're getting a lot of issues thrown at you in this environment, uh, and some you may be aware of, some you may not be aware of. We want to make sure that at least you know the things you should be thinking about as you try to navigate the difficult waters we're in. Okay. Um, Tell me you didn't see this coming. A disclaimer. This presentation is not the opinion of my law firm. It might not even be my opinion. Uh, if you do need legal advice, see an attorney, but hopefully we'll give you a lot of things to think about along the way. So what are the goals for business in this environment? Well, uncertainty is the key word. And what we're looking to do is we're looking to survive. We're looking to make necessary cuts. We're looking to increase flexibility, minimize liability, preserve and even potentially enhance relationships with customers, and position the company for recovery. Or if not recovery, if you don't have something to recover from, position you well for growth when we start stabilizing. So we're going to cover 10 tips. The first and probably the most important one, before I go to the tips, you really want to be systematic about your approach. And everything needs a catchy acronym. So I've called this RIAR squared. And the acronym stands for reassess. So, the world as we knew it on March 1 doesn't exist anymore. And if you're still functioning off of the same business plans, you have missed the boat. So the first step, once you realize that you've got to reassess, is doing an inventory. Figure out what your obligations are to external parties, what your relationships are like, and figuring out external sources of funding like the government. Um, then analyze. Figure out what action items you have to take with respect to each item that your inventory turned up. Finally, respond. Okay, go out and implement your game plan with respect to each of the items you inventory. And the key is repeat. Um, this is not going to be a static process. You need to constantly reevaluate, reassess, and run through this RIAR matrix again and again until the economy and the pandemic create a somewhat stable new normal. Okay, the first item is assure safety first, and this has to be the priority. We're dealing with reopening now. Um, this requires a lot of tough calls. Who is, when is somebody's presence really needed? Can you be accommodative? Um, there have been some pushes to create legislation that would give employees some shield from liability. Some companies are having employees sign releases. It's unclear how effective those releases are going to be, and at this point, there aren't shields. So it would not surprise me if you see a significant amount of liability I'm sorry, a significant number of lawsuits arising from this crisis. But you, uh, as the owner of a business, should be thinking about what steps you can create to create the safest possible environment in your workplace. And consider risk mitigation steps, taking people's temperature. When we get testing more readily available, do you implement testing protocols? How frequently do you do it? I just got a message that we lost audio. Please bear with me 1 minute. Okay, I've received messages that I lost audio, but I'm not confirming that. Okay, I'm going to continue on the assumption that that message was not directed to me. Okay, for the foreseeable future, we're going to have a significant part of the workforce working from home, and um, that requires adjustment. You have to look at your policies and figure out what tweaking is required for work for home. Even just very basic things like onboarding new employees, figuring out form I-9 and employment eligibility process. There are temporary processes that have been implemented to deal with that verification remotely. There could be an impact on visas, which are tied typically to a specific place where people are working. Uh, you have security requirements. If you're handling data that's governed by HIPAA, GDPR, the new California Consumer Privacy Act, the way everyone worked in the office may not, you know, may change when you go remote and may pose issues under those statutes. You have to do a review. You also have contractual obligations when you're handling that kind of data to third parties in a lot of instances. Again, you've got to verify that you update your policies, change your security practices so that people can become aware of the new risks. Um, Make sure that your suppliers have done the same, particularly your HR suppliers, benefit providers who are handling personal data. You really up and down the chain have to look for problems that arise when your workforce is now suddenly deployed at home. Okay. Unfortunately, one of the many downsides of this environment is that a lot of companies have to lay people off. And the key is to develop a cohesive process so that it's not done in a haphazard way and a one-off basis for each employee. You should have very uniform processes in place so that no employee can claim they've been discriminated against, and so that everybody is treated in a similar and hopefully dignified manner. First thing you have to do is look at your employment agreements. Make sure that the terminations comply with the letter of those agreements. So if there's notice periods, if there are severance payments, benefit continuations that are required, if people get accrued vacation time to which they're entitled, if they have options, if those options continue to vest, and how long, is there a minimum period for exercise? And keep in mind, with those agreements that classify uh, terminations as for cause, not for cause, most instances, these COVID-related terminations are going to be viewed as terminations without cause and with good reason. If you can, it's helpful to get a release from the employees that are being terminated. And this release should be combined with some form of additional payment that the employees are not otherwise entitled to. Now, it doesn't have to be a huge payment, but I wouldn't make it $10 either. And people have asked me kind of how much is the right amount. There's no bright rule. It's kind of more than de minimis, but you don't have to break the bank paying for it either. When you're doing layoffs, particularly if it involves more than one person, you really want to have a communications plan, both internally, how you're going to let other employees know, and if it is a significant number of layoffs, how you're going to communicate that fact externally. You want to be ahead of the curve rather than have reporters or chat boards light up discussing you. There's if you're really a fairly large company and you're doing layoffs of more than 50 people, unfortunately, there is the WARN Act that requires certain notices, though it's a question whether all of those requirements will apply at this time. Some companies don't do terminations; they do furloughs, which suggests the possibility of rehire when things settle down. From a legal perspective, they are identical in almost all cases. They will entitle the employee to unemployment. It might create an expectation of rehiring, so you want to be careful about calibrating the message. But when you're furloughing somebody from a legal perspective, you're terminating them unless your employment documentations or other company policy documents make that distinguishing. If a lot of small companies use PEOs, this would be like Asperity, Trinet, which create joint employment situations. If you've only hired through them and never needed to fire, you've got to work with them as well to comply with their termination processes. The good news is that they very often have a lot of materials already ready to go, kind of prepackaged termination policies and documentation, which you can rely on. Also, just a footnote, for those of you who run 401k plans and allow employees to borrow against that, the termination of employment will usually require the repayment of those loans, and that's something to be sensitive to. Important to tap all sources of funding. So you should be looking at federal and state programs. There are a lot of them. There have too many to kind of talk them through on this program. The most famous, of course, is the PPP, the Paycheck Protection Program, now on round 2. There have been a lot of issues with the PPP. The PPP, as long as you maintain the employment of the people that you would otherwise lay off for 8 weeks, makes the loan into a grant. The loan is forgiven. But keep in mind, when you borrow, in any context, you need to be truthful, but engaging in misrepresentations when you're borrowing from the federal government has even more teeth. There are requirements that you certify as to necessity, as to the size of your company, as to the use of the loan proceeds. There's a federal statute called the False Claims Act, which can in theory even result in criminal sanctions, but certainly fines if information is found falsely. And now we are entering the period where the 8 weeks are about up. So a lot of companies that borrowed under this program will now need to certify as to how those loan proceeds were used. And this is an important time to make sure that you've got all the necessary information, that it's accurate, and that you can certify to it. Okay, there are a bunch of employment law mistakes that companies that are under pressure typically commit, and that you really need to work to avoid. So, Rule 101: employees cannot work unpaid for any length of time, even if it's voluntary. There is no concept legally of voluntary employment. Um, and with very narrow exceptions, and this would be employees that own a large part of the company, they can't be compensated solely in equity either. At a minimum, you have to follow minimum wage laws. Uh, if it's done before they show up for work that day, you can agree with them that they can reduce their salary as long as it's in excess of the relevant minimum wage. But that can't be done after the fact. You can't come to somebody and say, "Hey, Bob, we're running low on money. I know you worked all last week. I'm only going to be able to pay you minimum wage." If you have that conversation on the first day of that week and say, "Hey, Bob, we're running low on funds. Um, I can only afford to pay you minimum wage. It's your decision whether you come or not. We won't hold it against you if you don't. Your call." And you document that fact, and the employee signs that fact, that in most instances will be okay. But even in situations where the employee is kind of feeling coerced to do that, there are going to be questions around that. Now, there's also a phenomenon, we saw this a lot in 2008. There are a lot of students that are on the market now, or very recent graduates who are just desperate to fill a resume. And uh, bottom line is, it is really almost impossible to legally hire an unpaid intern. The only situation where you can is if the intern is getting academic credit. There was a major case, I want to say about 2010, involving Condé Nast, the magazine publishers, who in the wake of 2008, with a lot of travel and fashion publications, brought on a slew of interns, and the court was not very sympathetic. And there have been more crackdowns on this as time has gone on, and I suspect in the current environment, there will be a lot more. Um, Finally, there's a lot of mythology around bringing on personnel on a 1099 basis, bringing them on as a contractor. Uh, and let's tick off some of the myths. So, myth number one is that if you call somebody a contractor and their agreement says contractor, uh, the law will treat them as a contractor. Myth number two is that it's easier to fire contractors. The reality is, in the United States, we have employment at will, and as long as you handle that correctly, you should be able to fire somebody at any time. Three, um, there's a mythology around 1099s that if you work part-time, short-term, so as under 3 months, under X number of hours a week, that somehow that allows you to be an independent contractor. Um, that is myth. Um, you can have, you can work 5 hours a week and be considered a part-time employee. You can have a contract that only runs 3 months, and then you're a short-term employee. But at the end of the day, in almost all situations for independent contractors, if you are paying somebody to their personal social security number, so not dealing with a case um, where somebody works uh, and sets up a company and bills you through that company, that largely has been held up as okay. But if you're paying somebody directly to their social security number, um, in almost all cases, notwithstanding whatever you write on their documentation, even if you try to pay them on a 1099 basis, they are what are called deemed employees. What you have done is considered misclassifications and can subject your company to back taxes, back taxes and penalties. I actually had a client a few years back who had a large number of independent contractors that they brought on board before I was engaged as counsel. They weren't trying to do anything wrong. They got bad advice. And then the company was acquired or was under consideration for acquisition. And the buyer basically required them to set aside $2 million in escrow for potential deemed employment claims because they had had a large number of contractors who should have been employees, um, and that was a source of liability. And the other issue with that is that once you've made this mistake, you can't go back and correct it. So yes, you can then try to hire your 1099, and that will limit your going forward liability, but you will still always have liability for the period that you treated the person on a 1099 basis. Um, we are halfway through the 10 points. So if there are any questions, um, please feel free to put them up now. Okay, we go on. Okay, most companies' second largest cost and probably largest non-variable cost uh, is real estate. Um, this is a time for you to reach out to your landlord. Courts are more likely to be more lenient with tenants that can't pay at this time. There are also a whole bunch of relief programs and stay programs that prevent evictions. Um, the longer you wait in approaching your landlord, likelihood is there's going to be less flexibility because there are going to be, they will have completed a whole bunch of other conversations with tenants looking for deferrals or renegotiation. Whatever understandings you reach with your landlord, critical that you document it, both what relief you're getting and for how long it's going to last. Um, there's a legal concept called force majeure, which means act of God. Um, and basically, it's a clause that if a party says an act of God has occurred, it can stop performing under the agreement. Uh, Force majeure clauses could be the subject of an hour-long presentation by itself, so we're not going to do it today. But if your agreement has a force majeure clause in it, your real estate agreement, or quite frankly, any of your contracts, and you're in a dispute situation, it is critical that you read it, perhaps consult with counsel and understand what triggers it, what are the consequences, to see if you are in fact in a force majeure situation under the contract, and who does that help and who does that hurt in the contractual relationship. Um, if your contract has a time is of the essence clause, like you'll often see contracts, uh, of talking about leaving the property at the end of the lease term, and the contract will say time is of the essence. So in normal times, time is of the essence means uh, that if you are late, even for a very short period of time, you are in breach. Again, I think that courts will be showing more flexibility in this environment, um, but I wouldn't push the limits of that too far. Okay, as I mentioned early in the presentation, um, one of the things you need to do is inventory your third-party relationships, and those are going to be primarily with customers and suppliers, and you need to measure and identify and try to address your risks with respect to both. So, with your customers, are they going to be able to pay? Um, are they going to continue the same order volume? With your suppliers, are they going to continue to deliver on time? Are they challenged? Are they having problems with their suppliers so they can't supply to you? How are these lockdowns impacting your suppliers and your customers? Um, so, to the extent you can, this is a good time to shorten payment terms on new customer agreements. Uh, when you have kind of net 60, net 90, you're carrying that customer for a long period of time. First, you probably prefer the cash flow in these times, but in addition, um, the longer the credit is out there, the greater the risk that something will happen and prevent the customer from paying. Uh, Especially when you're onboarding new customers, but even with old customers, ones who may have had shaky payment histories in the past, This is a good time to do some deep dive into their credit worthiness. Uh, you have to, you can calibrate this a bit by your cost of performance. So if you have a software-based business, a SaaS business, and your cost of servicing a customer is pretty low, you can afford to take on more credit risk. If on the other hand you're manufacturing product and you need to buy stuff to create that product, so now you're creating liability to service this customer, you might want to tighten the reins and make sure you're going to get paid. I mean, in extreme cases requiring cash in advance or letters of credit. Um, there's not an insignificant risk of bankruptcy out there. And in some cases, if a customer doesn't pay, um, you can actually initiate a procedure uh, to reclaim the property. Similarly, if you have a customer or a supplier for that matter uh, who you're feeling shaky about, there is a right in certain circumstances to send them a letter, what's called a demand for further assurances. And this letter basically says, hey, we have reason to believe you're not going to continue to perform uh, on this contract. Please confirm to us that you are going to perform. And if the customer supplier confirms, there are heightened consequences to them if they ultimately fail. Uh, but if they do provide you with further assurances, that should give you a better feeling about doing business with them going forward and helping your planning process. And also, if you're a supplier, this is a good time to try to establish second source supply, especially if you haven't historically. And if you have exclusivity agreements or minimum requirement obligations to suppliers, um, you might want to seek some limited exceptions to allow you to establish a second source for a limited period of time, um, and return to exclusivity when the world is a little bit more normal. I mentioned force majeure earlier. Um, Again, this is the act of God. One thing, the term force majeure is getting thrown around a lot because if a pandemic is not a force majeure, then what is? So two things that are important to remember about force majeure. One, if your contract doesn't actually have a force majeure clause, it is really hard to enforce the concept of force majeure. What do I mean by that? Well, in general, the courts don't like rewriting agreements. If the two parties agree to something, the courts don't want to step in and create a new agreement. The argument for force majeure uh, has kind of two parts to it. One, whatever happened um, is totally unanticipatable. So, sitting a year ago writing this contract, we couldn't have anticipated a pandemic. And at least now, you're probably likely to get some traction with that argument. Though I think in future contracts, if you don't talk about pandemics, I don't think courts are going to be quite as sympathetic. But the second piece of the puzzle is that act of God has to make performance virtually impossible. And that's not the same thing as more expensive. So, if pandemic has shut down all suppliers of the screw that goes into your product, that's probably a force majeure. If the pandemic has resulted in a situation where 4 out of the 5 screw manufacturers are out of business, but the fifth one is still producing screws, it's just 5 times as expensive, that's probably not going to be held in most instances to be a force majeure event. So when you can't rely on kind of general legal principles of force majeure, then you have to turn to the contract. And again, the courts don't want to rewrite contracts, so they enforce force majeure clauses very literally. And a force majeure clause usually says a list of things that constitute force majeure events, and then what happens as a result. And I think you'll see this change quite a bit. But if you look at a lot of force majeure clauses right now, they don't list pandemic. Okay. There's going to be a lot of contract renegotiations in both sales and purchase agreements. Um, Typically when you have contracts kind of uh, mid-cycle renegotiations are rare. Usually they happen when where contracts are up for renewal. I think all bets are off now, and you are going to see, and you will probably want to try to renegotiate a lot of contracts. Uh, this is going to be one of those early bird catches the worm type scenarios. I think the sooner you start these processes, um, the better off you're going to be because as your counterparties enter into lots of renegotiations and start giving up on more and more things, their flexibility with each new party that approaches to renegotiation is likely to be diminished. Um, so you've got to identify kind of things that you can horse trade. So maybe, um, if you need relief on price, you're going to be willing to lengthen the agreement by a certain period of time. Or if they're willing to drop price, you're willing to raise your minimum purchase requirements. What you really want to do when you're restructuring agreements is maximize your future ability, because none of us has a crystal ball in good times and certainly in these times. And you want to make sure that to the extent you can control your destiny. If you're getting a contract renegotiation, important to distinguish between um, temporary changes and permanent changes, and make sure you document. So all because you had a good call with a supplier or a customer and they said, yeah, we'll defer this, we'll do that. Make sure you document it, even if it's just an email exchange, but make sure you have some documented proof of the concession. Um, there is also an outside concern, which is you have to. There is a what's called in the law a concept of anticipatory breach, where you basically give the other side very solid reason to believe that you are not going to be able to perform. So you always have to walk a bit of a fine line in terms of stressing the difficulties you're facing to a customer or supplier without giving them a very valid belief that you're not going to be able to perform at all. So that's something to keep kind of in the back of your mind. Okay, this is a good time to review your insurance. There are first party policies that cover you against damages you suffer directly. There's third party liability policies, which cover damages to third parties. Uh, you know, Pandemic will probably have introduced a lot of changes to how you're doing business, where you're doing business. This is a good time to call your insurance broker and kind of walk through your coverages and figure out whether any changes are required. Also, if you are going to end up unfortunately shutting down your business, there is what's called tail coverage for officers and directors insurance. And so if you have third party investors in your company um, and the company shuts down and your insurance policy is on a claims made basis, your officers and directors insurance may not cover you for future claims. Insurance companies do, though, however, sell what's called tail coverage, and that's for a fixed period of years after shutdown that'll cover any claims that arose after shutdown. And if, unfortunately, that's the road you're going down, um, that's something to talk about with your insurance broker as well. Okay, I didn't put it as one of the top 10 practice tips because hopefully you won't get to these situations. But a word about insolvency. So there are kind of two and a half flavors of insolvency. There's Chapter 7 and there's Chapter 11. In Chapter 11, you renegotiate some form of settlement with creditors, but the company is allowed to continue in business when the process is done. It's often a very long and very expensive process. You actually kind of need to have enough money left over to be able to do this process successfully. So you can't run the tank all the way to empty. Uh, Chapter 7 is liquidation. The company's shut down, the assets are sold off. I mentioned that there were two and a half types of insolvency because very recently, and actually unrelated to the current crisis, a few months back, subchapter 5 to chapter 11, which applies to small business debtors. And it covers debts up to $2,725,625. I think that number is adjusted annually. Don't know how they came up with that exact number. But it's a simplified, streamlined process of Chapter 11 that gets you to the same endpoint, which is that the business continues in operation when the process is over, but it's much uh, 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 than a full-blown Chapter 11. And if you do fall on that limitation, and unfortunately you can't resolve and continue any other way, it is an option to consider. One word general: when the tank is getting close to empty, make sure you pay all taxes and wages, including accrued vacation time and severance, because um, in some situations, officers and directors of a company can be held personally liable if the company shut down and those amounts were outstanding. Okay, a couple of general points. First, communicate. When you have bad news, there's kind of a natural tendency to retreat into a shell. That's not going to be helpful here. So realize everyone's hurting, and when you're going to a customer or supplier with bad news, they probably have bad news, and if not, they've been hearing a string of bad news. Bad news is not an outlier these days, so fight the urge to hunker down. And communication can be very helpful because the other side of the conversation has information that they can then use to mitigate their risk, which ultimately mitigates your liability. Um, and the worst thing is, from a relationship perspective, is when bad news comes as a surprise. And if you haven't set it up with communications, you will do a lot more damage to the relationship as a result of surprise bad news. And in most cases, it'll make the legal consequences of bad news worse as well. If you have boards, investors with outsiders, again, normally you're a little reticent to share bad news with your board. Rely on experience, get their guidance. This is a resource you should be tapping. And one final point, there are a lot of tough decisions out there, and there are a lot of tough decisions in environments where you don't really have much of a choice. And so you're going to have to take the tough decisions, and you're going to end up hurting people in the process. But you will ultimately be judged by the manner in which you take these tough decisions and the manner in which you treat others that are involved in this. So to the extent you can show empathy, do it. To the extent you can soften the blow on the recipient, do it. Because once you develop a bad reputation, that can endure. Business failures, a lot of people will forgive you for, but if you act like a jerk in this crisis, that's something that can live long past it. And it's just not. First of all, it's the wrong thing to do, but it's just not good business. So I've written a whole bunch of articles that are related to the current situation. Um, Anyone who wants this presentation, please email me at Futter, dror.futter, I'm sorry, dror.futter@rimonlaw.com. Um, Shockingly, I am the only Dror Futter book that Rimon or anywhere on the internet, and I'd be happy to send it to you. And these articles cover a broad range of topics. Thank you again for listening, and good luck as we all work together to get through this. Have a good day.